We've all heard the horror stories about clashes with a homeowners association. But what happens when a really simple request for information, something that seems totally reasonable, spirals into a full-blown legal battle? Well, today, we're going to break down a real case that has this fascinating and honestly pretty unexpected twist in the rules that govern HOAs.
Okay, so let's just get right to it. This is the big question at the heart of this whole thing. You want to get in touch with your fellow owners, you ask for an email list, and the board just says, nope. Can they actually do that? Is that legal? Well, we're about to find out. So our story kicks off with a guy named Robert Tomisak. He's a condo owner over at the Arrowhead Lakes community in Glendale, Arizona. And, like a lot of homeowners, he wanted to reach out to his neighbors. And he figured he had a right to the contact info his association was keeping. And let me tell you, things moved fast. Just look at these timestamps. Mr. Tomisaki shoots off his email at 7:33 in the morning. Less than 1 hour later, at 8:23 a.m., he already has his answer. And spoiler alert, it wasn't the one he was hoping for. A little over a month later, this simple email exchange had completely escalated into a formal legal petition. And you got to pay attention to the wording he used here. He wasn't just, casually asking. He was making a very formal request, and he specifically cited Arizona state law. He really believed the law was clearly on his side, and that it gave him the right to see the owner's roster. But the association, speaking through their property manager, Terry Troy, saw things completely differently. They got the request, they looked at the exact same law Mr. Tomisak was citing, and they came to the total opposite conclusion. And this is where the fight really begins. And there's the denial. It's short, it's direct, there's no ambiguity. The association's entire argument boils down to this one key phrase: personal information. They were basically claiming that handing over an email list would be a breach of their members' privacy. So, with neither side willing to back down, the whole thing lands in an administrative hearing. Now, both Mr. Tomisak and the association have to stand up and try to convince a judge that their reading of the rules is the right one. And this slide just lays out the conflicts perfectly. So on the one hand, you have the owner, Mr. Tomisak. He's saying, look, the bylaws and state laws say I get to see the membership register, and an email address is not some kind of super secret personal info. But on the other hand, the association is saying, sure, you can see the register, names and addresses, no problem. But email addresses? Oh no, those are personal records, and the law says we can withhold them. So when you dig in, it all came down to these three key documents. You've got the community's own CC&Rs and its bylaws, which both seem pretty clear that records, including that membership register, have to be available. But that state law adds a really crucial exception, and that little exception is what this entire case seemed to be about. And here it is. This is the exact piece of the law that the association was leaning on. It says an HOA can withhold personal, health, or financial records. So the whole case, it seems, should boil down to a pretty simple question, right? Does an email address count as one of those things? Okay, so you can picture it. Both sides are in the hearing. They're arguing passionately back and forth about what counts as personal records. And everyone is expecting the judge to finally settle that question once and for all. But instead, the judge zeroes in on a completely different detail, a detail that, honestly, neither side had really focused on. This was the million-dollar question, right? This is what everyone was waiting to find out. It's what the owner and the association spent all their time and energy arguing about. So, are they? Is an email address a piece of private, personal information that an HOA has the right to keep secret? And the judge's answer was, it's irrelevant. It doesn't matter. In this just brilliant legal sidestep, the judge basically said, hey, you're all arguing about the wrong thing. The whole debate over what a personal record is was just a distraction from the real issue. So here's the knockout punch from the judge's ruling. The decision was simple. An owner has the right to look at existing records, but they do not have the right to force the association to create a new one for them. And that little distinction, well, that changed everything. And here's the kicker. It turns out the association had actually stopped putting email addresses in its official membership register all the way back in 2018, a full 2 years before Mr. Tomisak even asked. So the very specific document he was legally allowed to see, the register, it just didn't have the information he wanted. The association couldn't show him a record that literally did not exist. Okay, so this case is a great story, but what can we actually learn from it? It gives us some incredibly clear lessons that any homeowner living in an association can use about what your rights are and what your association's obligations really are.
So here are the 3 big takeaways. First, you absolutely have a right to see your association's official records. Second, yes, the law does allow them to protect certain sensitive information. But third, and this is the big lesson from this case, their job is to show you the records they already have, not to create new reports or special lists just for you.
And that really just leaves us with a final thought, doesn't it? This entire dispute probably could have been avoided if that one key fact, that the register just didn't have emails in it, was clear from the very beginning. It really makes you wonder, what records does your association actually maintain, and what information is in them? Knowing the answer to that might be the key to understanding your own rights as a homeowner.